EU-Canada Comprehensive Economic Trade Agreement, CETA, was entered into between Canada and the European Union and its member states on the 30th of October 2016. Certain provisions of CETA have already provisionally entered into force with effect from September 2017, but the full agreement will not enter into effect until the ratification by CETA by all member states. It is the proposed ratification of CETA by the Government of Ireland and Dáil Éireann by means of an Article 29.5.2 resolution that forms the subject of these proceedings. To understand the precise nature of this challenge, it is necessary to set out the essence of CETA and some of its more contentious provisions. CETA is a trade agreement setting the conditions of trade between Canada and the EU and its member states in respect of a large number of goods and services. It is, however, the provisions relating to investor protection and dispute resolution which have been the focus of debate in these proceedings. CETA is an example of an ISDS treaty, that is, an investor-state dispute settlement treaty. ISDS treaties have become a common feature of international law and practice and are in place between nations on both a bilateral and multilateral bases. Broadly speaking, under CETA, the parties agree that measures, which are defined to include legislation, administrative action and judicial decisions, will not offend against certain principles set out in the treaty. These principles of equal treatment, non-discrimination and fair and equitable treatment are to apply to certain covered investments made within the territory of one of the parties to the treaty by investors who are nationals of or established in another party to the treaty. In the case of CETA, the most important of these provisions for these proceedings are set out in Article 8.10 of the treaty. This provides that a party breaches the obligation of fair and equitable treatment if a measure constitutes, and I quote, A, a denial of justice in criminal, civil or administrative proceedings, B, fundamental breach of due process in judicial and administrative proceedings, C, manifest arbitrariness, D, targeted discrimination on manifestly wrongful grounds such as gender, race or religious belief, E, abusive treatment of investors such as coercion, duress and harassment, or F, a breach of any further elements of the fair and equitable treatment obligation adopted by the parties in accordance with the procedure established under paragraph 3 of this article. The procedure under paragraph 3 allows for a specialist committee to review the content of the obligation to provide fair and equitable treatment and develop recommendations for submission to the CETA Joint Committee, which is in turn empowered to issue binding interpretations of the treaty obligations. There are further relevant provisions of CETA, and recourse should be had to the judgment of my colleague, Ms Justice Dunne, for a more thorough explanation of the relevant terms. CETA also provides for an arbitral process to make determinations in respect of disputes. CETA permits claims to be made by individual investors for compensation in respect of loss suffered by them in circumstances where a measure adopted by a party is alleged to have breached the provisions of CETA. Chapter 8, Section F of CETA provides for the creation of a standing panel of arbitrators, 5 from Canada, 5 from the EU and 5 from third countries, all of whom shall satisfy the standards set for appointment of judges in their respective countries, and a further appellate body staffed by members similarly qualified who are empowered to review the decisions of the CETA Tribunal. This is in distinction to the standard model in ISDS treaties whereby disputes between foreign investors and host states have been settled by ad hoc arbitral tribunals constituted for the specific dispute. Article 8.29 also provides that the parties to CETA agree to pursue the establishment of a permanent multilateral investment tribunal. Furthermore, Article 8.221F and G of CETA establishes what is known as a fork in the road provision and provides that an investor, prior to commencing proceedings before the CETA Tribunal, must withdraw or discontinue any existing proceedings in domestic or international law and also waive their rights to initiate any further claim or a future claim or proceedings regarding the measure alleged to constitute a breach of CETA. Under the provisions of Article 8.23, claims under CETA may be submitted under the rules of the UNCTAD Convention, that is, the United Nations Commission on International Trade Law Convention on the Recognition and Enforcement of Foreign Arbitral Awards, 1958, known as the New York Convention, or the ICSID Convention, that is, the International Centre for Settlement of Investment Disputes Convention on the Settlement of Investment Disputes between States and Nationals of Other States, 1965, known as the Washington Convention. Both the New York and Washington Conventions have been ratified by Ireland, and awards made in arbitrations under those conventions are enforceable in Irish law under the provisions of the Arbitration Act 1980 and 2010, to which the respective conventions are annexed. The Constitution envisages that the state may enter into international agreements and Article 29.4.1 confers upon the government the executive power of the state to do so. However, this power is not without limit, and the appellant in this case contends that the ratification of CETA by the government is beyond the Article 29.41 power unless the matter is first put to the people by way of referendum. The overarching theme of the appellant's arguments concern the concept of sovereignty. It is contended that CETA is a breach of the internal sovereignty of the state in two principal respects. Firstly, the legislative sovereignty, and secondly, the juridical sovereignty of the state. In what may be referred to as the legislative argument, the appellant contended that the government is not entitled to accept the legal framework established by CETA without there being a domestic legal framework in place. Article 29.6 of the Constitution provides that no international law shall become part of the domestic law of the state, save as determined by the Oireachtas. The appellant argued that if the government were to ratify CETA, this would effectively allow CETA to become domestic law without having formally made it so, pursuant to Article 29.6. In addition, the appellant argued this would also mean that a body of laws made other than in accordance with Article 15.2.1 of the Constitution would determine disputes against the state and be enforceable within the state. This, it was argued, would be unconstitutional, as the sole and exclusive power of making laws is vested in the Oireachtas. Finally, the appellant argued that in this regard that the ratification of CETA could induce what was termed as a regulatory chill on the operation and application of Irish law and policy development. In other words, it was argued that the ability of the CETA Tribunal to make monetary awards against the Irish state may deter the Oireachtas from enacting laws likely to attract such awards. The appellant was particularly concerned about the application of this effect to law and policy in the sphere of environmental regulation. Secondly, in what may be referred to as the juridical argument, the appellant submitted that the ratification of CETA would fall foul of Article 34 of the Constitution, which provides that justice shall be administered in courts established by law by judges appointed in the manner prescribed by the Constitution. It was contended that because the CETA Tribunal is given the power to determine a dispute as to whether an act or omission of the state within Ireland breached CETA and can award monetary damages against the state on that basis which are enforceable within Ireland, the CETA Tribunal is effectively acting as a court, but not one established pursuant to Article 34, nor one permitted under Article 37. The state respondents, for their part, argued that the CETA agreement is an international treaty which operates at the level of international law and as such does not constitute the making of law for the state, contrary to Article 15. Furthermore, they argued that the determinations of a CETA tribunal would not constitute the administration of justice reserved to courts under Article 34 or bodies constituted under Article 37 of the Constitution. In this regard, the respondents noted a number of international agreements already in existence which permit individual complaints and provide for arbitration and binding determinations by a tribunal, most notably the European Convention on Human Rights, which has significant effects within the state, notwithstanding final determinations made by Irish courts and which does not offend the Constitution. Finally, the respondents argued that the fact that CETA awards are enforceable in Irish law was not a consequence of CETA, but rather the provisions of Irish legislation such as the Arbitration Act 2010, which is constitutional and has not been challenged here. In a careful and detailed judgment, the High Court, Ms Justice Butler, dismissed the appellant's challenge, considering that the provisions of CETA did not amount to a law required by Article 15.2 to be the sole and exclusive domain of the Oireachtas, and the determinations of a CETA tribunal did not constitute the administration of justice reserved to courts under Article 34 or court-like bodies under Article 37. All members of this court delivered judgments in this matter. The decision of the Supreme Court can be set out in two conclusions, which will, however, require some further elaboration. First, the Supreme Court holds that the Constitution of Ireland precludes the government in Dáil Éireann from ratifying the EU-Canada Comprehensive Economic and Trade Agreement, CETA, as Irish law now stands, and that is held by a majority of 4-3. Second, the Supreme Court, by a majority of 6-1, holds that certain amendments of the Arbitration Act 2010 would, if effected, permit ratification without breaching the Constitution. The reasoning of the members of the Court leading to the first conclusion can be summarised in 6 paragraphs as follows. The Supreme Court holds first, and unanimously, that the ratification of CETA is not an obligation necessitated by membership of the EU for the purposes of Article 29.4.6 of the Constitution, and is thus not immune from constitutional challenge. Secondly, 4 members of the Court, and in this regard Ms Justice Dunne, Mr Justice Charleton, Ms Justice Baker and Mr Justice Hogan, hold that the ratification of CETA would breach Article 34 because it would infringe Irish juridical sovereignty by permitting an international tribunal to make binding decisions enforceable in Irish law. Three members of the Court, Mr Justice Charleton, Ms Justice Baker and Mr Justice Hogan, also hold that ratification of CETA would offend Article 5 in the democratic nature of the state by permitting the interpretation and therefore amendment of CETA by the CETA Joint Committee without democratic oversight. 4. Two members of the Court, Mr Justice Charleton and Mr Justice Hogan, hold that ratification of CETA would constitute a breach of the legislative sovereignty of the state, Mr Justice Hogan considering that it does so by providing for damages awards against the state based on strict liability in respect of laws enacted by the Oireachtas, and Mr Justice Charleton considering that it permits laws to be made for the state otherwise than in accordance with Article 15.2. 5. Three members of the Court, that's myself, Mr Justice MacMenamin and Ms Justice Power, dissent and would hold that ratification of CETA would not infringe the legislative sovereignty of the state, and in that respect Ms Justice Dunne and Ms Justice Baker also agree. And finally, in this regard, 6. Three members of the Court, myself, Mr Justice MacMenamin and Ms Justice Power, dissent and would also hold that ratification of the provisions of CETA would not constitute a breach of the juridical sovereignty of the state, and Mr Justice MacMenamin would also hold that the challenge to CETA on grounds of an interference with the jurisdiction of courts under Article 34 of the Constitution was premature. On the second aspect of the Court's holding, 6 members of the Court, that's myself, Mr Justice MacMenamin, Ms Justice Dunne, Ms Justice Baker, Mr Justice Hogan and Ms Justice Power, hold that the Government and Dáil's ratification of CETA by way of an Article 29.5.2 resolution would not offend the Constitution if the provisions for enforcement of awards of the CETA Tribunal under the Arbitration Act 2010 were amended by the Oireachtas in the manner suggested by Mr Justice Hogan in Part 13 of his judgment, although this would be a matter for the Oireachtas. And finally, one member of the Court, Mr Justice Charleton, dissents in this respect and would hold that this course was not permissible under the Constitution, as it would contradict the terms of CETA fundamentally, and even a protocol to the treaty enabling this step would be contrary to the Vienna Convention on the Law of Treaties 1969. This course, furthermore, would not be effective as, on ratification, enforcement of CETA tribunal awards would become a legal obligation under EU law, which would override any domestic legislation. The effect of these conclusions is, as I have said, twofold. The Supreme Court, by a majority of 4-3, that's Ms Justice Dunne, Mr Justice Charleton, Ms Justice Baker and Mr Justice Hogan in the majority, and myself, Mr Justice MacMenamin and Ms Justice Power in the minority, holding that the Constitution of Ireland precludes the Government and Dáil Éireann from ratifying the EU Comprehensive Economic and Trade Agreement, CETA, as Irish law now stands. And the Court also, by a majority, in this case of 6-1, that's myself, Mr Justice MacMenamin, Ms Justice Dunne, Ms Justice Baker, Mr Justice Hogan and Ms Justice Power in the majority, Mr Justice Charleton dissenting, also holds that certain amendments of the Arbitration Act 2010, as detailed in Part 13 of the judgment of Mr Justice Hogan, would, if effected, permit ratification without breaching the Constitution. I should say that this summary is provided to assist in understanding the Court's decision. It does not form part of the reasons for the decision. The full judgment of the Court and of each of the members of the Court is the only authoritative document. And accordingly, the order of the Court will be to allow the appeal, to set aside the order of the High Court, and in lieu thereof, to make declarations in the terms of the two conclusions I have just outlined. Now, that concludes the summary of the judgment of the Court. Copies of the judgments will be distributed. It would appear, Ms Donnelly and Mr Rogers and Ms Barrington, that the order for costs should follow, but what the Court will do is to make a provisional order for costs in favour of the appellant in the High Court and in this Court, and will not make that order until this day week, and if before that either party indicates that they wish to take issue with an order in that form, and if so, whether they wish to have an oral hearing in that regard, they should set out those reasons in writing to the Court. If no such correspondence is received, then an order of the Court making in those terms, making those declarations and awarding those costs will be made.
All rise.